Thank you, Evan, and thanks to everyone for joining us today. I am delighted to welcome Justice Barry Alban to today's conversation as part of the Politics on the Public Mind lecture series. Justice Alban is an Associate Justice on the New Jersey Supreme Court, and it's important to make that caveat that in New Jersey, the Supreme Court is actually the highest tribunal, the highest court in the land. That caveat's necessary because in New York State, as some of you know, the Supreme Court in New York is actually a trial court. So in New Jersey, we like to identify things as they actually are. When we talk about a traffic congestion pattern, we really mean a lot of traffic. When we talk about extended, nice, pristine beaches, maybe not so pristine, but extended, nice beaches, we really mean extended, nice beaches. And when we talk about a Supreme Court, we really mean it's a Supreme Court. So Justice Alban comes to us from that court, and we're very pleased to have him today. I want to say a few words before I introduce the justice and talk a little bit about his background. I want to say a few words about his topic, but I won't say too much because it's his topic, and I don't want to take away from it. The topic is democracy and the uncertain future of individual rights. And that topic's an interesting one for me, and I hope to all of you, in part because there is a long discussion, a long scholarly discussion that has taken place, certainly for centuries in this country, but with some renewed heat and emphasis in the 1960s, focusing on what was famously called the counter-majoritarian dilemma or problem that is supposedly posed by courts. The basic idea, in a nutshell, is that courts, especially federal courts, but any courts, such as New Jersey's, that are relatively independent from political and popular forces, can potentially pose a problem for democracy, can potentially pose a problem for the people, insofar as they have the power to strike down legislation and other policies that are supported by majorities, or supported at least by the elected officials that represent those majorities. So that was a dilemma, or at least a theme, about the relationship between democracy and courts that coursed through the academy for much of the 60s and 70s, and certainly to the present. In more recent times, scholars have suggested that this dichotomy, or this setup, may have less than meets the eye for a couple of reasons. Some contemporary scholars have noted that in many important areas, our courts, especially their target seems to be the Supreme Court, are less anti-democratic than you might think, in the sense that many of the decisions of courts track or anticipate future public opinion or the views of large majorities. So that, for some, is perhaps a disquieting sense in which the courts need not be anti-majoritarian or anti-democratic. More to the point, and perhaps consistent with what Justice Alban will be talking to us about today, is the suggestion that, of course, courts support many of the values, norms, individual rights that are prerequisites to democratic functioning. And this view has been supported by the theorizing of political scientists and legal scholars, but also by some empirical evidence, which suggests that individual rights and the flourishing of many of the open economies and open exchanges of ideas require a certain kind of independent court system, or at least are supported by that court system. So this intersection, then, of the idea that there is a relationship, sometimes complex, between courts, democracies, and individual rights is one that seems to be front and center in our discussion today, but in a more general sense is a front and center discussion throughout much of the legal and scholarly community. To guide us through these important topics, we are very pleased to have Justice Alban with us today. And Justice Alban has been nominated by former Governor James McGreevey. He was nominated back in 2002 to serve on our state's highest court, and he was renominated in 2009 and approved, and has been serving since that renomination. So he's been serving in effect on this court since 2002 to the present. He is a sitting member of this court. He was a graduate of Rutgers College and earned his law degree, his JD, from Cornell Law School. Prior to serving on our state's highest court, he was a partner in the firm of Willentz, Goldman, and Spitzer, which is in Woodbridge, New Jersey. He also served as Deputy Attorney General in the appellate section of the New Jersey Division of Criminal Justice. He was an assistant prosecutor in both Passaic and Middlesex counties, and has been past president of the New Jersey Association of Criminal Defense Lawyers. So he brings a varied and rich background to his service before even sitting on the Supreme Court of New Jersey. He was selected by his peers as one of the best lawyers in America in the publication Best Lawyers in America. For present purposes, however, it's probably most salient, in addition to this rich background, that Judge Alban comes to us as a Supreme Court justice, as somebody who is in a position to make decisions on a daily basis that bring this intersection of democracy, rights, and the business of courts into combination and into practical effect. The New Jersey Supreme Court, as many of you know, has 6 associate justices and 1 chief justice. You may recall a couple of weeks ago we had a presentation by Assemblyman Carroll, who had many things to say about the court. One of the probably less controversial things he had to say about the court involved the contention that the New Jersey Supreme Court is one of the most powerful, one of the most influential, one of the most important courts in the United States. I think that's a view that is widely shared. We'll have to see, we can perhaps ask Judge Alban how he sees it from his perspective. But the bottom line is that observation suggests to us the importance of having one of the justices, one of these 7 individuals asked to decide cases that affect all of our lives on a regular basis before us. So I am delighted and honored to welcome Justice Alban to our Politics in the Public Mind session, and I hope you will join me in greeting him and thanking him for coming today.
Thank you for that warm introduction. In fact, Professor Peabody, Professor Woolley, Janice Recker, thank you for the lovely lunch that preceded. Now it will become my remarks. I thought that Professor Peabody summarized the issues I'm about to raise so well, so succinctly, that I hardly see any need to speak at all. We touched on it very well. I'm delighted to be here today at Fairleigh Dickinson University on a beautiful spring afternoon to give some remarks on a subject that is of great interest to me. I know that this event is part of a series on politics on the public mind, but just to be clear, in New Jersey, judges are not political figures. Indeed, it is our role to eschew politics and leave that subject to the other branches of government. So with your permission, I will not be political, but stay within my judicial role. This afternoon, I want to explore how we protect individual freedoms and extend equal protection to all of our citizens in a constitutional democracy. History tells us that protecting individual rights against the will of the majority has not worked perfectly, certainly not as some of the founders of our country intended. The title of my remarks is Democracy and the Uncertain Fate. You said future, fate's just as good. It's okay. Uncertain fate of individual rights. I want to talk about the role of an independent judiciary and the role of an enlightened citizenry in protecting fundamental rights when it may not be fashionable to do so. Let me begin with an unremarkable observation. Individual rights are likely to be threatened when popular support for a disfavored group declines. And inversely, those rights are more likely to be secure when the public is imbued with a healthy respect for individual freedoms. Each day in courts throughout the state and elsewhere, Courageous judges make difficult decisions that will not meet with public adulation or favor, but they make those decisions because faithful obedience to the Constitution and our laws commands the result. That is what we expect from an independent judiciary. We expect that the courts will be the bulwarks of our liberty and protect our fundamental rights, and when necessary, provide shelter to a despised minority or unorthodox views that may run counter to public opinion. However, on the great social and constitutional issues confronting one American generation after another, the conception of the judge as a figure of philosophic solitude who applies the law indifferent to the swirling passions and sentiments of the time has struck me as somewhat of a myth. On those great issues, the historical reality is that courts are likely to reflect the democratic attitudes of the time and often become unreliable guarantors of our freedoms. We see that when popular support for the individual rights of a disaffected group evaporates due to some traumatic national crisis, the Constitution sometimes goes into hibernation. We also see that when public support reaches a critical mass, courts are more likely to awaken and recognize rights that had lain dormant sometimes for generations. So let us explore how our courts have fared in vindicating individual rights when the democratic impulses of the day are hostile to a disfavored group or unorthodox views. From the beginning of the Republic, it was understood that independent and fearless judges would be necessary if individual rights were to withstand the shifting tides of public opinion. The fear of democracy running amok was one of the driving forces behind the adoption of the Bill of Rights. Various state conventions that endorsed the federal Constitution, some by very narrow margins, did so with the expectation that the new government would enact a Bill of Rights to protect the people from government oppression, whether coming from the legislative or the executive branch. James Madison had observed that individual rights look good on paper, but are difficult to keep against an implacably hostile majority. But there would be hope, so he thought, with an independent judiciary. In the Federalist Papers, Alexander Hamilton acknowledged that, and I'm quoting him now, it would require an uncommon portion of fortitude in the judges to do their duties as faithful guardians of the Constitution where legislative invasions of it had been instigated by the major voice of the community. He expected that judges would guard the Constitution and the rights of individuals and protect against, his words, serious oppressions of the minor party, even when public opinion was whipped up by demagogues. Those are my words. In that sense, a judge who is a protector of individual rights should not reflect the democratic ethos of the moment. We don't want our right to free speech or the right to exercise our religious beliefs determined by the vagaries of a poll and the shifting winds of popular opinion. How have we measured up to Hamilton's conception of the role of judges? Although rights may be abstract, unchanging, timeless principles, constitutional rights are tested in particular cases. The passions and the fads of the world in which we live will affect, to some degree or another, the way judges apply those rights. We cannot escape the reality that our view of the Constitution is shaped by the temper and spirit of our times. That is not judicial philosophy. That is historical fact. The wise and intrepid judiciary that Hamilton imagined needs to operate not just in the best of times, but also in the worst of times. Because it is in the worst of times that our constitutional rights are most at risk. Usually individual rights, the rights of a disfavored group or those espousing unorthodox ideas, are at greatest peril when there is a very real threat to national security or to the national existence, and the public is in the grip of a hysteria of fear. In the midst of a crisis, when alarm bells are ringing and when perfect knowledge is not attainable, it becomes difficult to gauge what is the real threat from what is the imagined threat. Some exaggerations may be the mistake of well-meaning people, and others the work of those eager to exploit fear for some cynical purpose. History is rife with examples where a minority or disfavored group has suffered in times of a national crisis because the judiciary was unwilling to defend individual rights against the widespread sentiments of an inflamed public. In 1798, the Congress, then in the hands of the Federalists, passed the Alien and Sedition Acts in reaction to the seizure of more than 300 American ships by France, which at the time was at war with England. The American public was outraged, and our country was placed on a war footing. The Sedition Act made it a crime to publish slanderous and malicious writings with the intent to defame the Congress, the President, who was then John Adams, or the government in general. The opposition party, the Republican Party, was then led by Thomas Jefferson. The government, armed with the Sedition Act, prosecuted and convicted Republican newspaper editors and even a Republican congressman before partisan Federalist judges, despite the fact that the Bill of Rights had been enacted just 7 years earlier. Jefferson described this period as the reign of the witches. The Sedition Act expired in 1801, the same year that Jefferson was elected president, who upon entering office pardoned all those convicted under a law that made it a crime to speak freely. After America's entry into the First World War in 1917, the administration of Woodrow Wilson, a progressive from New Jersey, ruthlessly suppressed speech criticizing the government's war policy. Those who expressed opposition to the war efforts in ways that would be deemed inoffensive today were prosecuted under the then recently enacted Espionage Act. In 1918, Eugene Debs, who had been the socialist candidate for the presidency of the United States 6 years earlier, gave a speech at a rally in Canton, Ohio, publicly voicing support for several of his socialist colleagues who had been imprisoned for their criticism of the war. As a result, Debs was charged with obstructing the recruitment and enlistment of servicemen into the armed forces. What did Debs do that made him the target of the prosecuting authorities? He spoke to the crowd mainly about his belief in the virtues and ultimate triumph of socialism, which in that day was viewed as a threat to the existing capitalist order. He praised his imprisoned socialist comrades. He declared that, quote, the master class has always declared the wars and the subject class has always fought the battles. And he added that, quote, that it is extremely dangerous to exercise the constitutional right of free speech in a country fighting to make democracy safe in the world. For making that speech, Debs was convicted and sentenced to 10 years in prison. That conviction was affirmed by the United States Supreme Court in an opinion authored by Justice Oliver Wendell Holmes, Jr., perhaps the most revered jurist of his time. Now, many others were rounded up and prosecuted under the Espionage Act because of their radical beliefs in opposition to the war. Not to be outdone, more than half the states passed their own sedition laws. Under Montana's sedition law alone, 79 people were convicted and 41 received prison terms. Those of German descent, in particular, were vulnerable to prosecution because the United States was at war with Germany. A traveling salesman was sentenced to 7 to 20 years for calling wartime regulations a big joke. In 2006, the governor of Montana pardoned those convicted posthumously. Justice sometimes comes a little bit late. After the bombing of Pearl Harbor and America's declaration of war against Japan in December 1941, a public wave of hysteria swept the West Coast, and the military commander of the region, General DeWitt, recommended the evacuation of the entire Japanese-American population on the ground of military necessity. By February 1942, President Roosevelt issued an executive order that resulted not only in the removal of 120,000 individuals of Japanese ancestry from the states of California, Washington, Oregon, and Arizona, but also their placement in detention camps, 120,000 people. 2/3 of those detained were American citizens. Although the justification for the executive order was military necessity, it was the product of fear, racial prejudice, and misinformation. General DeWitt, who as much as anyone was responsible for the removal order, referred to the Japanese as an enemy race and recirculated false rumors about planned sabotage as though they were hard facts. In a case called Korematsu versus United States, by a vote of 6-3, the United States Supreme Court upheld the mass evacuation and detention of Japanese Americans who had committed no offense against the United States. Justice Black, who wrote the opinion for the majority of the court, acknowledged that although most of those detained no doubt were loyal to the United States, the court could not reject the findings of the military authorities because of, quote, an unascertained number of disloyal members of the group. Not the type of proof that we would normally accept in a court of law. One of the dissenters, Justice Murphy, characterized the government's actions as the legalization of racism. Most Americans today would agree with that assessment. Korematsu represents one of the lowest moments in the history of the United States Supreme Court. In the late 1940s and early 1950s, during the so-called McCarthy era, the public was whipped up into a frenzy about the Red Menace, and suspected communists were hounded out of government and blacklisted in private industries, including Hollywood. During this time, the eminent jurist Learned Hand expressed his concern that America was entering into a new age of witch hunters, intent on rooting out heresy, enforcing standards of conformity, and choking off freedom of dissent. In that climate, leaders of the American Communist Party were convicted of violations of the Smith Act, which made it a crime to overthrow the American government by force or violence. The basis of the convictions was not action, but speech. the defendants' advocacy of the doctrines espoused by Marx, Lenin, and Stalin. The defendant's speech did not pose a clear and present danger to the nation's security. Nevertheless, in 1951, in the midst of the Korean War and the ideological war between capitalism and Marxism and communism, the United States Supreme Court affirmed the conviction of 11 of the defendants in a case called Dennis versus United States. That decision helped fan the already poisonous atmosphere that had overtaken the country. Justice Black, who wrote the Korematsu decision, now is in dissent. And he lamented in his dissent, saying, "Public opinion being what it now is, few will protest the conviction of these communist petitioners. There is hope, however, that in calmer times, when present pressures, passions, and fears subside, this or some later court will restore the First Amendment liberties to the high preferred place where they belong in a free society." Today, we condemn the prosecution of dissenters during the early Republic and the First World War. We condemn the internment of Japanese Americans during the Second World War. And we condemn the witch hunts of the McCarthy era. However, at those times, too few spoke up. Why did the courts fail to protect the fundamental rights of those who expressed radical views or those who just were perceived to be different? The answer partly is that judges are not Platonic philosophers removed from the hurly-burly passions of the day. They are your next-door neighbors, members of your communities, and subject to the same fears, misconceptions, and prejudices that may grip your fellow citizens. The hysteria that sweeps through every sector of society can also infect the courts. Courts are understandably loath to second-guess national security claims made by the executive. Courts can do much to preserve our freedoms, but they cannot do it alone. That is the message that I believe Judge Learned Hand tried to convey in remarks that he made to a group of immigrants to whom he administered the oath of citizenship during the Second World War. Hand said this: "Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. While it lies there, it needs no constitution, no law, no court to save it." So what is my point? Constitutional rights are more likely to survive the social and political upheaval caused by some national trauma when those rights find a deep and abiding respect in the public consciousness. Yes, it is a sworn duty of judges to keep faith with our Constitution, but judges alone cannot create the climate in which constitutional rights can survive and thrive. We all have a duty to promote an atmosphere of tolerance and respect for the rights of others. This was a point made by Martin Niemöller, a Lutheran pastor who discoursed on the moral lapses of the German people during the Nazi era. In a parable, he said, "First they came for the communists, but I was not a communist, so I did nothing. Then they came for the social democrats, but I was not a social democrat, so I did nothing. Then they came for the trade unionists, but I was not a trade unionist. And then they came for the Jews, but I was not a Jew, so I did little. Then when they came for me, there was no one left to stand up for me. So when some other presently disfavored group has its rights trampled down, do not ask for whom the bell tolls. It may soon toll for you. Now, I have spoken of times when the Constitution has gone into hibernation. Now I would like to speak of cases when the Constitution has awakened to the fullness of its promise, after progressive and enlightened advances in society have paved the way for the recognition of rights that may have lain dormant. There's no better example of constitutional redemption than the United States 1954 United States Supreme Court case of Brown versus Board of Education, which held that state-mandated separate but equal public school facilities for white and black children, that is, the enforced segregation of the races, violated the 14th Amendment's guarantee of equal protection of the laws. Today, that decision is taken as an article of faith, but then it was a brave and bold step forward in a country still infested with racial prejudice. Indeed, the decision met with determined resistance in the South, requiring President Eisenhower in 1957 to send federal troops to Little Rock, Arkansas, to enforce the Brown decision. In deciding Brown, the Supreme Court overruled the 1896 precedent of Plessy versus Ferguson, which had upheld a Louisiana law that made it a crime either for a black person to sit in a railway car reserved for whites or for a white person to sit in a railway car reserved for blacks. The court said the law was constitutional because the railway provided separate but equal facilities. In support of that outcome, the Supreme Court in Plessy noted that it was universally recognized that state legislatures could establish separate schools for white and black children and forbid the intermarriage of the races. Thus, in 1896, our nation's highest court sanctified the disparate treatment of blacks under state laws. Only Justice John Marshall Harlan, the only justice writing a dissent, said, "Our Constitution is colorblind and neither knows nor tolerates classes among citizens. The law regards man as man and takes no account of his surroundings or of his color when his civil rights are guaranteed by the supreme law of the land." When Plessy was decided, racial prejudice was deeply embedded in the habits and attitudes of the people of this country. And in many places, state-sponsored racial discrimination was a way of life and cruelly enforced, particularly in the South, through Jim Crow laws. Sadly, the majority in Plessy was probably in step with the times. The dissenter, Justice Harlan, who spoke of a colorblind Constitution, was the visionary, addressing the future, not a society ready to accept the true meaning of the words, equal protection of the laws. When the Supreme Court overruled Plessy in 1954 and discarded the separate but equal doctrine, it was not just that 9 different justices were on the court, but that those justices confronted a different world. What had changed between 1896 and 1954? The answer is much. Between those years, there developed a more enlightened understanding of race relations, and the agenda for racial justice had progressed through the democratic and legal processes and changing social mores. For one, a determined civil rights movement had come into being. The NAACP Legal Defense Fund, led by Thurgood Marshall, who would later be named to the United States Supreme Court, challenged discriminatory laws throughout the South and had won victories before the United States Supreme Court, which had ordered the integration of the all-white University of Texas Law School, graduate of the University of Texas, and the all-white University of Oklahoma Graduate School program. During the Second World War, whites and blacks fought and died together on battlefields in Europe and in the Pacific. Later, Harry Truman ordered the integration of the United States Armed Forces, and Jackie Robinson broke the color barrier in professional baseball. Moreover, a more tolerant and progressive attitude took hold in northern states. For instance, 7 years before the Brown decision, in 1947, the New Jersey Constitution specifically prohibited racial segregation in public schools and stated that freedom from racial discrimination was a civil right. It's right here in New Jersey in 1947. Didn't have to wait for the United States Supreme Court. Those social and legal advances paved the way for the Brown decision, which, though resented and violently opposed by some, particularly in the South, found acceptance in the nation. Yes, it took courageous judges in Brown to render the decision, but a critical mass of public support made the outcome possible. Just 4 years ago, in the case of Lewis versus Harris, the New Jersey Supreme Court declared that our state constitution guarantees that every statutory right and benefit conferred to heterosexual couples through civil marriage must be made available to committed same-sex couples. 30 years before the Lewis decision, it would have been inconceivable that any court would consider conferring all the statutory rights of marriage on a committed same-sex couple. What changed in New Jersey in the 30 years before Lewis? Not the words of our state constitution, but rather the social and legal landscape to which we applied those words. During those years, there developed a better understanding about homosexuality and the rights of gays to live and work as equals in our society. Popular culture through the medium of television and movies broke down stereotypes and dealt maturely with the subject of homosexuality. Moreover, through legislation and judicial decisions, this state, step by step, extended protections to gays and lesbians. In 1992, the legislature made it unlawful to discriminate on account of one's sexual orientation, and in 2004, it passed the Domestic Partnership Act, providing committed same-sex couples certain rights and benefits that are accorded to married couples. On the judicial front, New Jersey courts held that a gay or lesbian could not be denied his or her parental rights, such as custody or visitation rights, or the right to adopt a child. Later, the New Jersey Division of Youth and Family Services began placing foster children into the homes of committed same-sex couples. When we, the members of the New Jersey Supreme Court, applied the equal protection principles in Lewis versus Harris, the world in which we lived was different from earlier eras that could not have conceived of the notion of gay rights. What can we learn from the Brown and Lewis decisions? Constitutional rights need an enlightened and tolerant environment in which to take root. And the responsibility for fostering that environment falls on all of us, not just the courts. Oftentimes, constitutional principles evolve in tandem with the changing society. It may be less likely that constitutional principles will change the face of society than that a changed society will accept the application of constitutional principles as applied to a disfavored group. So the final message that I wish to leave with you today is that however bold and courageous judges may be, on the great issues before us, their way will be made easier when people, in the best of times and in the worst of times, are imbued with the spirit of liberty, a spirit that is committed to protect the fundamental rights of the disfavored, the unorthodox, and just those who are perceived to be different. The students here today will bear the torch of freedom into the future. If you learn not only from the mistakes of the past, but also from the many examples that have made our constitutional democracy stronger and better, I am confident that our nation will continue to be a beacon of hope to all the world in the future. Thank you.
Thank you, Justice Alban. My name is Dustin Jacobs, and I will have the first question today. And if anybody else has a question afterwards, please raise your hand, and we will try to get to you. My first question is regarding the newest issue with Abbott versus Burke, Judge Doyne's opinion. My question is, how heavily does his opinion affect yours and the rest of the justices' what your outcome will finally be?
We're hearing argument in Abbott versus Burke next week, and as a member of the court, I'm not supposed to prejudge the decision, but I can say this about Judge Doyne's report. When it comes to questions of credibility, because there were witnesses who testified before him, we're supposed to pay a certain level of deference because he was there and he's able to see how the witnesses appeared and who was believable, who was more credible. On the issues of law that he addressed, those come before us in what we call a de novo review. In that manner, we don't owe him the same respect because we can read the law as well as he can. So therefore, we're going to have to figure out what is the right thing all for ourselves. And we'll be hearing argument next Wednesday, and stay tuned. Does anyone have any other questions?
Considering our country's current war on terror, do you think American Muslims are now at risk of having their personal liberties and individual rights stepped on, like as previous groups of minorities have in the past?
Did everyone hear that? The question was, given the so-called current war on terror, do Muslims possibly are they possibly exposed to the same fate as other minorities, having in different times having their individual rights trampled on? Which is, the answer to that question is we have to be ever vigilant. Okay, it's 2011. Do you remember the atmosphere in this country shortly after September 11th, 2001? That was a frightening time. Now, I remember a person who was dark complexioned. He could have looked as though he had come from the Middle East, and in fact, he was of Indian descent. He was an electrician, had come over to my home. This was in the days just after September 11th. And I went outside, and I saw his wife sitting in the car. I asked her, "What are you doing here? Why don't you please come to my house?" And I said, "Why are you even here?" And she said that she was concerned for her husband in the present climate. So today, when in calmer times, as Justice Black had said, when emotions are subdued, I'm proud to say there seems to be a great climate of tolerance in this country to to Muslims, as there should be, as for every minority group. But the great test, because we're in better times now, is when some horrible act can occur and people are trying to pin it on a group rather than an individual. So we have to be careful not to ever engage in sort of collective responsibility on an entire people or group for the individual acts of deranged people or some small radical groups. So, am I concerned? I'm always concerned about the atmosphere that exists in the country, and that's part of the reason for this talk. It's all up to us to make certain that we keep our heads in difficult times.
Thank you for your very enlightening speech. My name is Michael. I'm a political science major. I'm in Professor Woolley's New Jersey politics class. You made some very interesting points as far as the effect of social climate on judicial decisions, insofar as a more liberal social climate will provoke these progressive decisions like Brown v. Board of Ed, when we know more, and that sometimes the court has to stop democracy from running amok. Now, feel free to correct me, but it sort of seems like you're painting a picture wherein judges have a responsibility to take positive social trends and apply them while guarding against negative social trends. Would you agree with this, or how do you feel about it? And if so, what do you think, I don't want to sound crass or anything, but what do you think gives judges that moral right?
Well, you're starting with a very foundation that or premise I may have to disagree with, because I don't believe that courts are necessarily the ones to promote progressive societal trends, whatever that means. Okay. Our job, as I see it, is to enforce the principles of the Constitution to particular cases. Now, that may seem enlightened to some people. In Brown versus Board of Education, applying the term equal protection of the laws to African Americans was considered a very progressive and forward-looking thing to many people in the North. But there were people in the South who were ready to go almost to war with that particular issue. The governor of South Carolina had threatened to remove all public monies from the educational system if the Supreme Court of the United States ruled as it did. As it turned out, he didn't do that. And we know that there was foot-dragging that went on for years and for decades. And even the United States Supreme Court didn't think that it was going to be able to drag the country into the modern era, if I'm calling the modern era an era where blacks were given their full rights. Because in another opinion, they said that the enforcement of this particular constitutional decision will be through all deliberate speed. So, sometimes a constitutional ruling maybe seem progressive. It may just be the right thing. It may be what's demanded under our Constitution. And that's true of the Lewis decision. So, now, of course, judges have to guard against imposing their own social mores or attitudes, values on the Constitution, because the Constitution certainly just can't reflect my values. So we attempt not to do that, even though we're criticized of doing that. So the short answer to your question is I see my job as applying the Constitution to the facts of a case before me. Whether that's considered progressive or regressive is, I guess, for critics and scholars and other people to later decide.
I know you said in a previous question that individuals, like everyday citizens, have to stop kind of discriminating against certain groups because of one individual's actions. Well, is there anything the legal system or judges in particular can do besides that? Or are they just a part of the everyday citizens group because you said judges are your neighbors and everything else? Are they a part of that group, or is there anything the legal system can do that we as citizens can't do?
I can't stop a mob. I can't do that. You know, as one individual, I tried to give assurance to the poor wife of my electrician. You know, judges have a limited role. I'm here telling you about my concerns, trying to educate the public. You know, the legislative, the political branches of government have an important role to play in educating the public. And there were many responsible public officials after September 11th who were warning Americans not to be taking actions against Muslims in general. There were Muslims who were killed in the World Trade Center. These were the acts of a small band of sort of murderous, radical renegades. And we just have to be careful about stereotyping people, particularly in this country, the most diverse country of all the nations in the world, a country that has welcomed immigrants from every continent. We represent the entire world. We're sort of the United Nations of the world. And we have a special responsibility to show tolerance to others.
A big issue that's been going on for a couple months now that may have to do with what you're talking about of tolerance is in regards to Arizona's new immigration law, where some say that may be a form of discrimination, the act, or it's a state dealing with a state problem because the federal government, according to Arizona, is not dealing with the border, and so they need to act upon this and protect their citizens from potential threats, drugs getting into the state and the country, and murders that have taken place on the border. So I think Monday it was a judge in Arizona struck some parts down, but I think the only court that really is going to make a difference here is probably the Supreme Court. So if and when it does go to the Supreme Court, in your professional opinion, do you see the law being upheld as a kind of states' right, or will be thrown out because it's not upholding to the liberties of not having discrimination and being tolerant?
I don't like ducking questions, but I don't ordinarily give advice to the United States Supreme Court. And I'm even more reluctant to do that because a case that I authored on the New Jersey Supreme Court is presently before the United States Supreme Court. So I don't think that it's wise for me to engage in a decision that has been recently been rendered by a federal court in Arizona and try to prognosticate how the United States Supreme Court will decide that case. It's difficult enough for me to decide cases in this state.
Jeffrey Tobin in the Nine credited Sandra Day O'Connor as being very pivotal, as being representative of the majority social opinion. Could you comment on that? Did you read the book?
I did read the book. Having read the book doesn't make it any more easier for me to comment on it. I read her opinions. People have said that Justice O'Connor was in the center and was pivotal in deciding many of the cases. But it's difficult for me to say whether Justice O'Connor or any other particular justice somehow reflective of the majority of the nation.
I meant more vis-a-vis being representative of the conscience of the country.
I know he may say that, but the people who disagreed with her think that they're the conscience of the country. So,
in the beginning of your speech, you said that judges in New Jersey are not political figures. Is that completely true? And if so, why? And is that the case in any other state?
Well, for one, we're not elected, which I think is pretty good. And I think I just read this morning that 22 of the highest courts in the United States, the justices are elected. And in fact, recently there's been a lot of attention to a race between two contenders for a spot on the Wisconsin State Supreme Court. And that whole race was becoming a referendum as to recent political decisions by the governor. So the question is that any way to elect a judge? Maybe not. I mean, a judge should be appointed or elected based upon judicial ability, scholarship, intellect, independence. One of the great things about the New Jersey system, because judges are appointed, is that the judges are more likely to be independent of political influence. Who would want to appear before a judge in a case and think that your case may be decided because of some opinion poll being conducted by someone? You want your case decided on the facts according to the law. You want an impartial judge. You don't want the judge having an eye to whether or not he's going to be reelected. You want him doing justice. And that becomes much more difficult, I believe, in a system where judges are elected. But apparently in those states where they elect it, they love it. So that's, this is a federal system. We have different states, different strokes for different folks. But now our state, all of the judges are appointed. Judges are appointed for a period of 7 years, after which, we can call it a probationary period, after which judges are subject to renomination by the governor and then subject to advice and consent of the state senate. So that's the way it's done in this state. I think it's worked pretty well. New Jersey has one of the most respected judiciaries in the country. And I'm not giving a shout out for the Supreme Court of New Jersey. I'm talking about our trial bench and our intermediate appellate bench.
The court has been labeled an activist type of court. As a member of that court, do you have an opinion in reference to that? Do you think it's condescending to the court?
Well, first you have to tell me, is activist a good label or a bad label? For the people who use it, I think it's used as a pejorative. So when a person is calling a judge activist, what is he saying? He's saying, oh, that judge, he doesn't interpret the statute. He doesn't follow the Constitution. Oh, that judge is merely expressing his own will and trying to superimpose his values on society. So if that's what it means, then of course I deny the charge, because I do my best to read a statute as it's written, follow the plain language, and attempt as best I can to enforce the will of the legislature. Okay, they're writing the laws. I don't have a tax policy, a labor policy, or some other type of policy. I'm trying to read a statute and figure out what the legislature's intended. Now, when it comes to the Constitution, due process of law, unreasonable searches and seizures, those are broad, majestic terms that the people who drafted them expected to be used and applied to the contemporary realities of the time. In 1800, there were 4 million people in the United States. There's a horse and buggy era. We have to apply constitutional rights to the modern realities. There weren't telephones. You weren't able to intercept. You weren't able to hear through walls. So, how you apply these terms, unreasonable searches and seizures, are different from any possible conception that the people could have had back in 1800. So, we have to apply, I don't want to say adapt, apply broad principles to contemporary realities. Using precedent, I'm just not off on my own. When I'm deciding a case, there's normally a number of decisions that have preceded anything that I might write by decades. And we're taking principles that evolve over time and attempting to resolve cases that are uniquely before us.
Justice Alban, thanks again for speaking today. And my name is Rajon Rayford, and I'm also in Professor Woolley's New Jersey politics class. And I was just wondering if you could maybe weigh in on Governor Christie's recent decision to privatize the Meadowlands racetrack, keeping in mind the job losses that might result from the privatization.
My first remark was that I wasn't going to be political today. I'm a judge. And that is a decision that is for the other branches of government. I think it's not appropriate for me to weigh in on those decisions. So I have to understand and respect the limited sphere in which I'm working. I'm a member of the judicial branch, so that's a matter for the Assembly, for the State Senate, and for the governor to resolve.
Thank you, Justice Alban, for coming.
Thank you very much. Thank you.